Right, okay, all right, all right, we're doing roll now, sorry, guys. Chair Wallen here, Vice Chair Reynolds. You need to
Excuse me,
unmute,
here.
right? And Commissioner Miller.
Here.
For staff, Executive Director Armstrong.
Here.
Commission Counsel Bassett. Commission Counsel Bassett.
Here, sorry. I was reading a text from Commissioner Reynolds.
It's gonna be one of those days. Investigator Terry. Acting Associate Counsel Hazlitt.
I'm here.
Senior Legal Researcher Pagni. Here. Outreach and Education Officer Harvey.
Here.
And Executive Assistant Saldana.
Here.
Please stand for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God,
indivisible, liberty and justice for all.
Executive Director Armstrong, has the commission received any public comment via email to be read on record?
We have not.
And are there any members of the public here who are wishing to do public comment?
There are not here physically in the room. I'll defer to our executive assistant to see if there's anyone on the Zoom.
Elvira Saldana, for the record, there is no one, no public members in Zoom.
Great, thank you. First item, approval of the minutes of the November 12th, 2025 Legislative Committee meeting. Commissioners, do you have any changes or additions to the minutes as presented?
I have no changes. I'll make a motion to approve them as presented.
Is there a second?
I'll second that.
All those in favor say aye.
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 Opposed, motion carries. Next item, review and discussion of draft legislative language proposals and possible approval of legislative concepts to forward to the full commission for consideration. Executive Director Armstrong, please give us your presentation.
Thank you, Vice Chair. In the materials you have some suggested legislative changes based on the topics that this committee has previously brought forward. I did want to provide an update on the timeframes. We got notification last Friday that agency legislative proposals will be due to the governor's office by March 15th. That is shortly before our March meeting. And so I asked if we could turn them in the day after our meeting because we needed full commission approval. And that was authorized. So at the March full commission meeting is when we'll want the full commission to approve whatever the submission will be. So that's just to know for your time frame, and we can discuss at the end whether you think if we need a February meeting or if a meeting, the March meeting is before. We'll figure that part out at the end of the meeting. But in your packet, so you have these topics that we have discussed. These are, of course, my drafting. The way the process works is, LCB gets to do all the official drafting of the BDRs, but I thought having the actual language would be helpful. So the first one is, goes through. The first one is mandatory training. I'll just walk through them each and talk about each, and then we can discuss at the end. So to me, it made sense to put the mandatory training requirements, if that's the one you choose to go forward with, in the same section as the acknowledgement forms, because we talked about starting with just public officers being required to complete training, which is also the same universe of people who have to complete the acknowledgement. And so this requires the training to be done within the 30th day following the day they take office. It adds to the acknowledgement form that they say they've completed the training, and then it also creates a new violation, that willful refusal to complete the training or to execute the acknowledgement can create a violation of the law. So that's mandatory training. On page 2, you'll see unwarranted harm. It's the same language we had the last time we had a bill in terms of what unwarranted harm is. There was some talk about appearance of impropriety, and actually in some prior bills, we had sought to tackle the definition of appearance of impropriety. So that's the same language that we have used before. Again, the appearance of impropriety piece goes to essentially a defense or an exemption to the ethics violation of use of time, property, and equipment. It's one of the 4 prongs under the acceptable use exception to 400 subsection 7. On page 3, you'll see gifts. And this is probably the most, complex one for us to figure out because there's so many different approaches across the country in terms of gifts. So the proposal today would be to define gift, so it's clear what a gift actually is. We don't currently have a definition of gift. And then it also adds factors for the commission to consider when they're determining whether the gift would tend to improperly influence a reasonable person to depart from the faithful and impartial discharge of their duties. Those factors are things that the commission has considered before in cases and then also influenced by some other states. So those 5 in here, the current 5 factors are if their attendance is clearly for ceremonial purposes, like throwing the first pitch, that type of thing. The extent to which attendance was offered is broadly available to the public and media. That the event provides educational information clearly related to the public officers or employees' public duties. That kind of codifies our cases about conference attendance and those types of things. The value of the gift is a factor we have discussed before, and the ability of the public officer or employee to make official decisions regarding the individual or entity providing the gift, which is that decision making access. That was really established in the city of Reno case before. Then on page 4, you see we had talked about potentially going with just a stricter cooling off provision, which just says like for 1 year you cannot work there, period, or you cannot lobby them, period. It doesn't have to be on something that was before you at the time. You just can't, like if you leave the city, you can't go to the city for a year on anything and get paid to do it. And then the last one would be an expansion of confidentiality provisions. And there's two modifications in here. One is we had talked about there's these situations where someone like works at an agency, they saw bad conduct and they leave, and currently our law doesn't really allow them to get confidentiality protections. So this would say if they were at the same agency at the time of the conduct, they can get that confidentiality protection, like if they as if they still worked at the same agency. And then the last one relates to substantial economic harm to the requester if the identity is revealed. So those are just these are my thoughts and additions. I think for the committee, if there's any topics missing we want language on, we should talk about that. If there's language in here that you think is not quite right, we should talk about that. And then I think some discussion about either prioritizing, the decision for the committee will be in March. Do you go to the commission and say, we want to do a bill on this one topic? Or we want to try to do 2 bills, one on this topic, one on the other topic? Or like we want to try to get all these done in one package. So I'll turn it back over to you, Vice Chair, to lead that discussion, and we're all here as a resource.
Right, fellow commissioners, questions, thoughts?
Well, I have a question on it for Ross. One is, well, there's 2 questions I have. One is that on gifts, is when you have duties involved in education about the event, you may not be, sponsoring the event, but you may be involved in, traffic, different aspects of the event and need to go there to watch the event. F1 is a good example of that, where, there's a financial impact to the community, and the county commission was looking at, what the impacts are to business, to, other aspects of the event. And so does this wording, and I looked at it and I think it does, but I want to make sure that it does cover those types of activities.
Yeah, I think the under 3, where it says the event primarily provides educational, and I guess that would be the question is, does the word primarily cause an issue there? Because F1 isn't an event that it primarily provides educational, right? It primarily provides a race. But the attendance provides clearly educational information, you know, for the person. So there may be, we could work some language there that says their attendance provides them educational information clearly related to their job.
Yeah. Ross, I'll give you an example. I was involved with the Super Bowl, and there was two issues. One was the area that was blocked off, and then transportation. Transportation is a big issue with the Super Bowl, moving people in and out, you know, to the stadium and to the various events for that. And you have these large scale events. Obviously, that had a substantial impact on everything from buses, limos, taxis, and I didn't go to the event, but the commissioners for the NTA and the Taxi Cab Authority had to be there to see the event, or events like that to see that. And so that was my concern, to make sure that those types of activities were covered with this language.
So let me ask you this question. So are they inside watching the game, or are they outside watching the track?
You have to actually be physically present to see what was going on. And you were involved in terms of making decisions. The commissioners were involved in terms of making decisions as to the activities and how they were going to handle transportation. And so it went through, and there's a lot of different aspects of that in terms of what was open, what was not open, what routes were going to be used, all those types of things. So they actually had to go see it. Not everyone, but somebody had to be there.
But if they were inside, they wouldn't be seeing the traffic issues.
That is absolutely correct.
So they were outside.
This is all outside, but you're within the event.
Being outside of the event, I mean, I think if somebody were to have a complaint filed against them regarding gifts, and that this was educational and their job was to watch for traffic and getting people in and out, you don't need to be inside the event. You should be outside.
Well, you do. You're going to have to be inside the event. I'm not going to go into nitpicking it, but you're going to be, even on the outside, you're in the event because they wall it off. So where they have,
to get to that, to get to even where the problems were, you had to
you had to be there.
So,
anyway, that was one of the questions I had. The other one on the cooling off period, I don't agree with a strict, you can't work there at all for a year. I know that presents some issues, and this is a difficult one, but I think it's worth the time to be able to get an opinion for the individual that will be affected by that, and encourage that, the opinion, and get the word out. And I know we do, but get the word out to those individuals of what they can do and what they can't do. So I think it's important. I think a strict, you can't go there, you can't work there, is really too restrictive.
Yeah, let me respond to that one. So the language in the materials you have is focused just on 281A 410, which isn't about where you can go work. That's all in 550. 410 is like essentially the lobbying prohibition for a year. So right now, like, let's say that you worked at, I don't know, like anyhow, and it's so your wildlife, and you get hired by an entity that has some business in front of the Department of Wildlife. Now you can get paid to go lobby them, as long as the issue that you're being paid to lobby wasn't at the agency while you were at the agency. We recently had a case involving the Reno city manager. The Reno city manager left his service at the city, went to work for a law firm, and then lobbied on data centers. And we got a complaint about that. Well, the data center application from that entity wasn't before the city while he was there. And so he could get paid to go lobby the city within that 1 year. It was fun, right? So that that investigation resulted in a dismissal. So they could go still work wherever they want to, but it would say, like, if you're gonna go work for a law firm, you can go lobby at any other entity you want during that first year, but you can't go back to, you can't go back to the Department of Wildlife and lobby them. So that would be this one. Doesn't restrict where you can go work. It restricts you from lobbying your old agency within that year time period.
And I don't have a problem with that, Ross. It sounded like you wanted to have a broader brush on that.
Yeah, and I'll note that 410 is not an area where we can provide relief.
Okay.
Important now. They're
No, it's pretty specific.
550, we can give relief. 410, it's just a complete restriction.
Yeah, I too had the same concerns as Commissioner Reynolds on that one, but your explanation, I'm fine with that.
I'm good with that too. Just thank you, Kim.
Commissioner Miller,
I don't know if we go far enough on gifts. I mean, I know we have nothing now, so this is an improvement, but it leaves a lot to still be desired, but maybe a starting point is what is required. And this is that starting point.
The gifts is a tricky issue. I looked at some other states, and I mean, Oregon has like 18 different provisions related to it about what so this is an area where you could ask me to go back and provide a more robust option. And because here we just generally define gift, and then we say these are factors the commission should consider, which isn't something that we really have in any other of our provisions. We do somewhat when we talk about a violation, and if it's willful or non-willful, there's a 7-factor test. And we do when it comes time to questions about issuing relief. But in any of our violations, we don't really have sort of a factor or weighing test. You could sort of say that the appearance of impropriety part of the limited use exception is one where we have a factor test. But if this committee would like, I mean, we can go much more prescriptive. I know that we're at somewhat of a disadvantage compared to some other ethics commissions across the country. And I think Commissioner Reynolds will appreciate this in that we can't make any substantive rules by regulation, right? A lot of these other ethics commissions, there's a gift prohibition in the law, and then they can regulate all these, so if an issue pops up, they adopt a new regulation so it's clear for everybody. We don't have that legislative authority. And so this current language tries to get to where we want to have some factors where there's clarity for public officers out there, but also isn't like a 20-page change to the law. But we can go this. I imagine that this would be the topic of most discussion during today's meeting is how do we really want to tackle gifts?
Well, I think we also have to, the real goal for us is to give us the clarity of how we're looking at it. And I think this does do that. The question is it giving the giftee or potential giftee enough clarity on whether or not they can take that? And I think that's kind of what we're trying to oscillate between, right? We have no clarity now. This gives some clarity, but does it really give enough? And I don't know. I look back to everyone else. I think over time, our decisions related to it could give some guidance to people. But initially, I'm not sure this change does that.
And we can certainly add factors too in here if there are other areas where it would be more clear. Or
Yeah, Ross, I think that would be helpful to add a little more clarity, for lack of a better word, but a little more definition or clarity. I know it's difficult without, you don't want to specify it too tight, but you also want to try to cover the bases. So it's a balancing act.
Uh,
I definitely don't think we want to go down the road of Oregon. I think that's a tough thing to get past in general. I think that would make it very difficult. So I'm not opposed to the approach, but I do think maybe a little more, maybe a part B that defines some limits for us, or I don't know. But yeah, I think there's a way to make that one a little bit more robust.
are there suggestions on factors or definitions to add?
Well, I mean, in the first clause, they shall not seek or accept any gift. If they have a commitment in private capacity, which would tend to improperly to influence a reasonable person, okay?
And that, sorry,
That's-
that should be black, because that's all current language.
And I know, and so all we're adding is part A, if they attend an event, okay? So we haven't really clarified people
What it-
getting gift baskets and,
I
dinner.
think I think the other thing to define there as well, and I agree with you. I think unsolicited gifts should be referenced. That's one thing. But I also think maybe we define what it means to seek a gift. Like, we look at emails when we get after discovery, we look at emails and, well, it'd be nice to see. It'd be good to go and experience, those kinds of things. What does it mean to seek? And I think we could maybe give some clarity on what that looks like and how we're going to look at it. Because that is a key component of it, right? Not seek. What does that mean?
Mhm. Yeah. But I think we need some clarification on, we're really addressing attendance at events, versus, what if someone said, well, it'd be really nice if you'd let me fly in your private plane and I'll do this for you. I mean, that's not an attendance at an event, and it's not gonna influence me, I'm totally impartial. So I think we need some clarification around that.
Thank you for your permit application. I
Uh-huh.
really enjoy reading it.
Yeah,
Yeah.
exactly.
Right.
I mean, so I think we need to get some clarity there, like Commissioner Miller says about seeking a gift. And people, it happened to me as controller, people would send gift baskets to the office. I didn't take them home, I just gave them to my staff. I didn't even eat anything out of them. But, I mean, those are just, I think we need to kind of have some clarity there. And, the value of, under here, the value of the gift, I mean, I don't know if we can define that or not, because
But that's something we can consider, right? That I think that I like that approach, Ross, of saying these are things we're going to look at, right? And I think that was the goal. And it does get your point. We can't really put a number on it, and then you got to go back for inflation in 100 years or whatever. I think if we just say it's a factor that we're going to look at, I think that's probably the right way to go about it without having to have this something get revisited. But I think one, unsolicited gifts should be referenced. I do think what it means to seek, right? Any reference to a desire and an indication that you would appreciate in any way. I don't know how we want to word that, but there's something about giving them the concept of what does it mean? What does seek mean?
Okay.
yeah, I think those are considerations there. Any other comments about gifts? I mean, I think the gifts is gonna be a work in progress. I think this is gonna be a start. I don't think we can come out with a statute that covers everything at this point in time. And, and like you said, I don't wanna have it be something where it's like 20 pages of law that, a person has to go through. I mean, that just sets people up for failure when you have something like that, so I think that would be good. I do have one thing on confidentiality. I like what you've added there. I know that at our last meeting, in the full commission meeting, Chair Scheer brought up, he said, have you guys considered disclosing the requester at some point in time if confidentiality has been granted. Thoughts on that?
So we currently do not, at any point, if the commission during the jurisdictional phase grants confidentiality, we at no point disclose the identity of the requester. Currently, that's the state of the law. There is a provision in there that says, if we cannot prove the case with, like, essentially, if that confidential requester is essential to proving the case, you can't prove it without them, then you're not supposed to go forward with the case. That's as close as we get to saying,
Okay.
you know, like, something happens and you maintain them as confidential. The other part around that is when folks request confidentiality and they don't qualify, when they file a complaint, they have an option to have a complaint withdrawn automatically. And that does we maybe have, I don't know, 3 to 5 of those a year, maybe, where someone says, if I don't get confidentiality protections, please withdraw the complaint. The vast majority say, oh, I'd like confidentiality, but if I don't have it, go forward anyway. So that's that is that. It's but I do, you know, I do get the concept of the idea of having the ability to face your accuser. Our process is a little bit different in that when you guys take jurisdiction, and really when you get past a review panel, it's the commission that is the accuser, not the person who filed the complaint. It's not. It is not similar to like the victim of a crime, where that they've been the one specifically harmed by this conduct. We are independently making the determination that this violates the law.
Commissioner Reynolds, did you have something to say?
Well, I'm concerned. I think there can be a real chilling effect if you have the option to, you know, go back and make that person's name known. You know, who the person that filed the complaint. So I like things the way they are. I know it's not perfect, but I think it's important that there are protections with that. You know, we looked at the whistleblower laws in the state and had a lot of discussion on them in terms of protection, especially with OSHA complaints and different, you know, complaints within businesses or within entities. And it really does have a chilling effect if the person has to give their name out on that. So I think it's important to have some confidentiality depending on what the issues are in terms of who's presenting it and what the to who they are. We are looking at in terms of the hierarchy of employment.
But I think the language we added basically says, you know, if you worked and you no longer, we're trying to extend that. I think that's the goal. At least that's the way I read it, right? Like,
yeah, and John, I agree.
We're trying to make it even clearer that our ability to say that their identity remains confidential, even if they no longer work there, is relevant. And then on 3, that, you know, if they offered, you know, reasonable likelihood of disclosure. So I feel like we are kind of doing what you're saying. I think that's our intent. That's what it reads to me. So
Yeah, and I agree with that, John. I think we're there. I just don't want to go too far on it for disclosure of an individual, because I think that would make a chilling effect on bringing complaints.
Yeah, and I'll say when we have our, think about how best to characterize, when we have our most nervous requesters, right, who are in an agency and they're like terrified about filing a complaint, they usually call and ask for thoughts. And I always tell them, whatever you do, make sure, especially if you're at a small agency, list yourself as one of the witnesses. Because if you're an agency of 5 people and you list the other 4 people as witnesses, then like it'll be easy to figure out who would. But if you add yourself to a witness, it kind of helps mask who may have filed that complaint. But we do, you know, I'll say, like, there have been maybe 2 or 3 cases where we've granted confidentiality under B, the bona fide threat of physical force or violence. it's the folks who are working in the same agency, especially small agencies they get real nervous, and they usually have really good information and those complaints have gone far. But I would agree with Commissioner Reynolds that if they knew, okay, we're gonna keep it confidential at the beginning, but at the end it will be revealed, I think it would have a chilling effect.
That was my initial thoughts on that as well, just because, I mean, if you say, all right, it's gonna be confidential until we get to the hearing. Well, one, if they still work in that same agency, their life is gonna be miserable. And two, if they're working at a different agency, there could be retribution, even though they're at another agency. Or it could even prevent them from getting a job because they filed, it came out, they had filed a complaint or something, so. Okay. All right, so,
I did have a question, if that's all right, Chair Scheer.
yes, go ahead.
Just as like a thought process, what is the benefit of having the requester public? Like, even if they don't want to be confidential, right? Like, obviously we can't accept anonymous complaints, but what is the utility of having that be public information?
I think that probably coming from Commissioner Scheer is like, you have a right when you're charged with the crime to question the person who is accusing you, okay? But as Executive Director Armstrong pointed out, that now the accuser is the commission after it goes past panel. So,
Right.
so
I guess my thought is like, are they required to be a witness to the degree that they're willing, in the sense of any witness that is called, right? Like, are they just not considered a witness as opposed to like a requester, right? Like if all requesters were confidential and the person who initially submitted the complaint was automatically a witness in addition to other witnesses that they brought forward or that commission staff identified, like what are the downsides of that?
Well, I can tell you for our process, as part of the investigation process, and it's we always interview the requester. Whether or not that requester would be a witness at a final hearing, it depends on the nature of how, like, if that requester has any personal knowledge of what happened, or if they just like saw a media report and said I should file a complaint about this. I know that the idea, I believe, about not accepting anonymous ones is that helps prevent a lot of frivolous kind of nonsense from coming in. We still don't take jurisdiction on most of our stuff. So, but I don't know that there's any necessary reason to disclose who filed the complaint to the requester. Like, I don't know. I think it's probably a good due process right of the individual to know who filed the complaint, except in narrow circumstances. That's all my thought is on that.
yeah, I don't see, unless that requester is the only one who can supply us with the evidence. There's really no reason to reveal their identity if we've granted them confidentiality.
Right. I think Sam's question is like, is there any value ever in disclosing who that is?
Well, I mean, to make them all confidential, I don't know. I think
Yeah,
that
it's just an interesting. I was like, how would I think about it if I was coming at it from the other way of like, if they were confidential just because they are the requester and we pretended that that's normal, right? Like, what instances would it be necessary for them to not be confidential? And if we think about it that way, even if we don't change it in that way, right? Like, how does that change how we might want to write it?
It's an interesting question, right? Because
Yeah.
the way our system is set up, having come from now two different perspectives on this, we don't allow a requester to withdraw. I mean, once they file it and we take jurisdiction, I mean, I would generally, sometimes requesters would call and be like, oh, I want to withdraw it, or I don't, Instead, like, it's not your complaint, it's our complaint. Once we take jurisdiction, it's the commission's complaint against the subject. It's not the requester versus the subject, it's the executive director versus, right, like on behalf of the commission. So in
Yeah.
some ways, their identity really isn't, I mean, if they're a witness, that's one thing, but I would say a good number of our complaints, we really don't require, we don't rely on the requester for really any of the information. Generally, we
Right.
obtain that all, you know, independently through public records requests, subpoenas, depositions. Occasionally, I mean, there's the rare subset where they are the main source of information, but I would say that's pretty rare. We don't allow, we generally in the past have always granted motions not allowing a subject to try to use the motivations of the requester as a defense, because it doesn't really matter, you either violated or you did not. You know what I mean? Like, why somebody alerted us to your violation isn't really relevant to whether you actually violated, right? Like,
I think that speaks to like the language that we use,
warrant of
right? Like,
criminal action isn't really relevant either. It, you know what I mean? Like, you don't actually necessarily get to even, you know, cross-examine that person unless they are a witness, but I
so
don't
is the
know. I think it's
requester
a good
filing a
point.
complaint?
I
Right?
don't
Like, are they filing a complaint or are they making the commission aware of potentially unethical conduct and we are filing a complaint? Right? Like, is that a change in the framing that like
Well, I
is
guess
tangential, but
my issue is that I think these are substantial policy issues that really need to be, you know, considered by the legislature and in legislation if we're going to go to that point. It's something that I think that, you know, it's a policy issue that because there are issues that are within either city or county or state government that are protected by um, their ordinances and their charter in terms of how they do business in the state, in terms of how they handle employer types of complaints for that. So we're getting off into an area I think which is difficult, and I think, you know, it's a substantial policy issue that we can bring to the entire commission. But I would lean on the side that the legislature should be the one, or the definition of defining employee relationships in the state or within city and county government in terms of how the complaints are brought on that. And we see a lot of complaints here, as you probably are very aware, and Ross I know is, of employer types of complaints of whether they don't like the way things are done or they, you know, feel that they were wrong in terms of how the employer treated them in their activity. And so I think, you know, there's a crossover there and we need to be careful with that. So, you know, and if I would lean to more protection than less protection, but there also, I think it's a policy issue that we need to hash out in a little broader context than what we see.
Yeah, I think that, you know, I don't think that our provisions that we have really stopped our complaints coming in, you know, with how you get confidentiality, how you don't have confidentiality. I think that to just make it all blanket confidentiality, I would be concerned that there'd be a lot of frivolous complaints coming in, you know, if everyone was confidential and, you know, so I think the way it is right now is good. And I like how we added the fact that with financial harm or economic harm, adding that, and the fact that if you were at an agency, now you aren't at that agency, you still are granted the confidentiality if you file a complaint against an individual at the agency that you had worked for. I think we've tightened it up, okay? But we haven't just made it just blanket, everyone's confidential, because. So that's my 2 cents. Can we let him or not? Or does he have to wait till public comment?
What?
Can I weigh in?
We have to wait, we have to move.
Well, that's a good question.
Yeah, I mean, the fact that you're keeping LinkedIn out of there, I'm concerned that.
Oh, we're just worried about a quorum issue.
Yeah,
There.
you bring,
So,
yeah, so if you bring in linked and you got,
yeah,
so
but I think, well,
you can.
I can wait till public comment.
Yeah, you can open up
Yeah.
public comment at any.
yeah,
point.
if you, just so we stay straight. All right, we don't want to get in trouble.
And I'll note that we do have an item on the
Right,
full
yeah.
agenda today for
To
discussion.
discuss this.
And just for a note, I mean, I'm not necessarily advocating we try to change our statute to make everyone confidential. I don't think we'd ever get that through.
No,
I think people are very attached to the idea that they should be able to know. I just point out the legal way our statutes are set up, it essentially makes them not relevant as once we take jurisdiction, like to our process and the way the commission makes its decision, the commission doesn't weigh as a defense who the requester was, right? I mean, that is not one of the elements of any of our violations or a defense to neighbor violation. So just pointing out, it's not really a necessary piece of information most of the time. I think it's mostly just that subjects would really like to know who turned them in.
and I think that, I don't know what session it was, but I think that we had a confidentiality provision in there that when we give the requester a copy of the complaint, that instead of kind of being redacted, that it would be like an executive summary of the complaint to help protect the identity and stuff. So, I mean, but then back then, I think a lot of our complaints were sent in by paper, so you could recognize handwriting and things like that. Whereas now they're all electronic. So I don't think we have that issue that we had before.
Yeah.
You know? So.
Yeah, I guess
Okay.
there's not a downside to saying like a typed version of the request if it was handwritten for the however many we get of every couple of years. But
All right. Let's go. Okay, so my fellow commissioners, any other comments on the proposals that our executive director has put forward regarding training, unwarranted harm, gifts, cooling off, and confidentiality? Not seeing none.
None from me.
So that's like 5 items.
Yes,
Yeah.
it's fine to me. And we're presenting these to the full commission at our next meeting, assuming we can get the grace period of the day.
Yeah, we have the grace period, so
Yeah, they were very quick to say.
Okay.
yeah. So we have 5 items. I know when we met last time, we said, what are our top 3? Because,
Yes.
you know, when, and, you know, splitting the bill up into 2 bills, I don't see where that's gonna get us. Well, that might get us something in the sense they might say, oh yeah, okay, we'll do this one, but we're not gonna do this one. But then if they do that, is that gonna be something that we really wanted to have? So first item, thoughts about splitting it up into couple bills? And if so, which items would you put in those couple bills?
I guess I would vote not. I would not be in favor of doing that and splitting that up. I think it's important to have a comprehensive package and go through and do that. If you spin it off into separate bills, you always have the issue, and you're probably very aware of this, Commissioner Wallen, about having your bills taken and changed mid-session and coming out was something completely, aside from what you were trying to do. So I prefer the more of a putting the top items into a comprehensive package.
Okay, and so if
I concur.
you concur, all right, so are you guys comfortable with doing 5 items? I'm trying to, how many in our last bill that failed, how many items did we have in that one?
I think 35.
35.
Yeah.
Oh, so this is much better. Okay, all right. Okay, this is much better.
I see these as the 5 as very important. We still have to go to the full commission, but I see these 5 as, substantial issues that need to be brought to for decision making on it. And so I don't think it's too much. I think it's actually fairly good. And explaining those, I don't think causes a lot of difficulty. Where 35, or major comprehensive issues where you have to really go through, makes it very difficult, as you know.
I think, in some of our previous bills, the things that really gave the legislators heartburn was extension of time.
Yeah.
They just, but staff hasn't had that issue where they haven't been able to meet the deadlines. In the past, we were having some of those issues. And so that was one of the things. The other items were making the executive director had to be an attorney. They didn't want that. But we don't have an issue there. I mean, the commission can hire whoever they want, and we can always say being an attorney is preferred, when you're hiring for another executive director. And I'm looking at these. I don't see where confidentiality would give them heartburn. Cooling off. I think if it's explained the way our executive director explained it, I don't think they'll have a problem with that either. Unwarranted harm. I think that's a good thing because we have had cases that have come before us that we had no jurisdiction over because this wasn't in there. The training, I mean, who knows? I mean, if they decided, okay, I don't like this bill because of the training, well, that's too bad because we're trying to keep people from coming before us by having them take training. So, and it's not unreasonable, and we're not saying that they have to do it within 30 days of being sworn into office. They can do it up to 30 days after they've been elected, right? Am I correct?
It's 30 days on the date which they take office. So if they're elected in November and they take office in January, they can do it.
Okay.
It's very reasonable.
Yeah, I do. I would say based on my own experience in analyzing training bills and determining whether I needed a fiscal note or not, the training one is out of these items the most likely to bring forth fiscal notes from agencies who might not want to do it because they'll say they have to.
Can we put something in here that the training can be done online? Because that's not a fiscal note if it can be done online.
Let me think about that. Let me think about how we could, I think because it's limited to public officers, we're probably gonna be okay, right? If it was every public employee, they're like, I have a 1,000-person agency.
Right, yeah,
Now I have to take them
and that
off.
takes their time away.
I've got to pay for overtime so that the correctional officer can go to ethics training, but because it's limited to public officers.
But I think I wanted to make sure that they understand that you can take the training online. And you can do it in segments. You don't have to,
And that may be, I don't know that there's a benefit of putting that language in the statute, but part of the explanation.
I just something to prevent a whole bunch of fiscal notes.
Yeah, let me think.
I think, as a bottom line, I think it should be online. Obviously, enhanced training is more beneficial, but what I'm seeing in public officers and the amount of cases that we have with city and county officials, that they should at least go through online training at a bare minimum.
Mm-hmm. Yeah. So Commissioner Reynolds, all 5 are good for you. Commissioner Miller, all 5
are good for me.
Yes.
changes. All right.
There's actually 6.
6.
6.
Oh yeah, unwarranted. Yeah, okay, 6.
Yeah.
I'm just an accountant. I can't count. I don't have my shoes on. So, Any other comments or anything like that? But I appreciate the work that staff has done in putting this together. I think you guys have done a really good job. We'll probably have to have another meeting in February to finalize this before it goes to the full commission, because you're gonna come back with some additional wording on gifts and things like that, but we'll just do it by Zoom.
Okay, we scheduled. No, that's not enough time, I don't think. I would, if you guys want to schedule it,
Yeah,
I would say the week of February 23rd would be my preference.
I can do it the 23rd, 25th, 27th. What's everyone else's schedule, Doug?
Looking,
I have tax appointments now, so.
Oh, 'tis the season.
Yes.
I can make those work, those dates work.
Those dates work, okay.
Yeah, 23rd is not good for me. 23rd, 24th, 25th.
We did like 1:30 on the 25th.
Does 25th work?
No,
Okay,
Oh.
how about the 27th then?
27th is good.
So you can't.
We don't work that.
26th or 27th.
Okay, hang on here, let me just see something here. Okay, if we can do it on the 24th at 4.
24th at 4?
Mm-hmm.
Yeah, I'm out of town that day, so.
Oh, I thought you said you could do.
Said 26.
No, I'm out of town the 23rd to the 25th.
Oh, okay, so 26, okay, 26, 4 o'clock.
Yes.
Is that okay for you guys?
Yeah, I can do the 26th and 4.
Okay.
Curtis will be the main presenter. Yes, I'm joking. That's the bar exam.
I haven't had it that week.
Well, then you'd have an excuse. All right, okay.
And then what does the process usually look like when it goes to the full commission? Because obviously after the commission meeting, it has to be finalized the next day. So like there wouldn't be much time for adjustments from the full commission.
No, I mean, I think that we'll have our proposed language and then the committee will make its presentation to the commission will say, yes, we want to do all 5, or no, let's do these 3, and then they'll do their approval. And
That's it, yeah.
our I think what is due to the governor's office on that day after is really like, this is what we want to do, and this is
Oh.
why it's important. It's not the actual language, because that
Whether or
gets,
not there's an and or an or in that. in
Yeah,
line 5.
that LCD
Yeah,
gets to
no, it's-
control that. And
It's not, the commission, full commission doesn't go and do wordsmithing. It's basically, these are the concepts that we want to take forward. Are you guys good with it? Great, that's it. It's not like, what else do you guys want to do?
That's good to know.
Because we don't
I
have time
didn't
for
submit
that.
anything last session, so I didn't know how it went.
And they sent the initial stuff and I haven't looked deeply at it, but we'll want to attach how each of these proposals aligns with the governor's strategic plan and that thing. So, which is easy to do.
Mhm. Yeah. Okay. All right. With that being said, I will now entertain a motion to accept the executive director's report on the proposed legislative concepts, along with our additions and fine tuning of certain items regarding gifts, possible saying that it's online training. And the main things were the changes to gifts and online training that we talked about. I didn't see anything else in there. Good, so I'll entertain a motion. Who wants to? Commissioner Reynolds, you have to unmute.
Sorry. I will move to accept the report on the legislative items from the executive director with the recommendations that were discussed today by our legislative committee regarding the items brought forward by the executive director.
Is there a second?
I will second.
Right. All in favor, say aye.
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 Opposed? Motion carried. All right, commissioner comments. My fellow commissioners, any comments that you would like to make? Future items, okay. Public comment.
Two things quickly, on confidentiality. I don't think I'm as concerned about the confidentiality of the requester's identity as I am about more of the substance of the complaint and the process. We've had complaints from some of the subjects of proceedings that they were not aware of enough of what was going on with the process. So because it's all confidential until after the review panel meets, is there a way to make more information available, even if it's not the identity of the requester? So that was what I was getting at more. And then secondly, on training, under the Nevada Constitution, legislators technically take office as soon as they are elected, which might be as long as when the county commission certifies the results, but usually within a matter of weeks of the election. So, and they have orientation typically in January. You might want to make that 90 days, or at least for legislators, look at a longer time period to have mandatory training.
Good point. Well, that'll be exempted out
Most likely, but
because they do their own training. Right?
they do, and they do it as part of their orientation.
Yeah, that's part of their orientation, so they may just even
Yeah, I mean,
carve it out.
they may not object because they're already doing it, it's just the timing.
Yeah,
And I'll note there was a bill last session that includes ethics for onboarding requirements for NG regions. So there are some entities already doing the training, which I think reduces fiscal note concerns.
right. So now I will ask Executive Director Armstrong, have you received any emails?
We have not.
Okay. And we've already heard from the member of the public that's here. Are there any people on Zoom who want to make public comment?
Elvira Saldana, for the record, there are no members of the public on Zoom.
Right.
I'll make a quick public comment with regards to training, just for the commissioners to think about the degree to which we want to be able to enforce the training requirement, and if there's any mechanisms we want to build into that. Because we know refusing to file acknowledgement or refusing to do training is not something that, unless they email us and say, no, I refuse to do this training, right? It's an interesting process. So whether other states have built in like accountability pieces of like who's completed their training online, just something to think about if that's something we're interested in pursuing.
All right, with that, I will entertain a motion to adjourn.
So moved.
So move
All
second.
right, all those in favor say aye. Aye.
Aye.
Opposed, motion carries. Thank you, everybody.